My daughter is my beneficiary in my revocable living trust. Upon inheritance of my home, would she pay capital gains? All right, so this is a really good question. I think it stems from me talking about capital gains tax through a ladybird deed and how you get a step up in basis, which, by the way, somebody had pointed out you don't have to have a ladybird deed for a step up in basis. This is true when you inherit property, whether it's through a trust or a ladybird deed or actually just through the plain old probate process. You get the step up in basis. But the big things that I try to point out, or the big point that I try to make with ladybird deeds or revocable living trusts, is you have the benefit of avoiding probate. If you don't have a trust in place where your home is owned by the trust, or there's a ladybird deed to the trust and then it passes to your beneficiary, or a ladybird deed which goes directly to a beneficiary, and the property just passes through a will or just passes through the regular Florida law of inheritance, then there does need to be a probate in those instances when there's no trust or no ladybird deed. All right, but back to the question at hand. So now we have a property that is in a revocable living trust, which means this property would have been transferred into the trust, and the trust, the revocable living trust, is now the owner of the property. And this property through the trust is going to pass to the daughter upon the death of the person who created the trust. So if your daughter inherits this property and then she sells it soon after the inheritance, typically we like to say within 6 months to a year, she's probably not going to have to pay much, if any, maybe none, maybe nothing at all for capital gains tax. And that's because the same is true for inheriting property through a revocable trust as if she was listed as a beneficiary on a ladybird deed. If it's in a revocable trust, keyword revocable, which means, the grantor can make changes. The person who created the trust can change it during their lifetime. So in this type of trust, when you pass real estate to your daughter under this type of trust, she does get a step up in basis, which means when she sells the property, she gets to use the date that it passed to her, your date of death value, as essentially what her taxable basis is in the property, as if that's what she paid for the property rather than what you originally paid whenever you bought the property. So if she's using that date of death value as her value for taxes, and then she goes and sells the property within 6 months to a year, it's very unlikely that the property would increase to a point where there would be any gain there. She's probably going to be selling it for more or less what the value was when she inherited it. And that's what we mean by that. Meaning there's not going to be any gain there, because if she inherited it, fair market value was, say, $900,000. She sells it 6 months from now, it's probably still going to be very much in that same range. So there's not going to be a gain realized there for her to have that capital gains tax. All right, I hope this answered your question. If you have any other questions regarding property and how it passes through either a ladybird deed or revocable trust, or if you have no documents in place at all or just a will, any other estate planning questions, and you're in Florida, do not hesitate to reach out to our office. We're at Cause Law Office, the Non-Stuffy Attorneys, and the link is in my bio.